And yes, the webcast can go back on. There's a question. I see some nodding. Yes. Mic 22.
Hi. Thank you very much. My name's Aline Sigurdsson, and I'd like to thank the chiefs present, the executive elders, guests, and colleagues for the opportunity to contribute to this 50th Annual General Assembly of the UBCIC. It's a genuine honor to be here in Kamloops, Secwepemc territory. And I'm humbled and inspired to be in a room with such powerful and respected leaders, especially on this anniversary. And I want to acknowledge all of the powerful, persistent work of resistance and rights recognition that has come before in the last 50 years, and see it as the wind at the sails of the work for the next 50 years. And acknowledge the women and men who have done that work and on whose shoulders we can all stand. And I'm very, very grateful for that. I was asked by UBCIC to do a presentation on the BC Treaty Transformation Discussion Paper and talk about what it does and doesn't do. And the key message of my presentation is that the approach described in the paper does not go far enough to address the significant concerns that the UBCIC has had since the start of the BC Treaty process. There should be a presentation in your binder. And I know this is a topic that's very familiar to people who have been in these rooms, and so I intend to keep my remarks brief because I anticipate and I expect that there should be a discussion and that will be vigorous as necessary. What is this treaty transformation document? BC has published the draft discussion paper, after the change of government has happened, and after a process of engagement with stakeholders in 2016. And this document is intended to set the stage for engagement and discussion with stakeholders about changes to be made within the treaty process. Many here are obviously very familiar with UBCIC's engagement about the treaty process because that has been ongoing since before there was a treaty process. But the concern has been expressed repeatedly over the years about the treaty process being inconsistent with the UBCIC's understanding of what a treaty should represent, which is the reconciliation of Indigenous sovereignty and Crown sovereignty involving relations on a nation-to-nation or government-to-government basis.
If you're looking for the deck, it's in tab 1 behind the third blue colored page.
Okay, thanks. Now, the substance of UBCIC's concerns with the process have been worked on and refined over the years, and I've recorded in your deck a list of concerns that was generated in 2016. So if you were at this assembly in 2016, you'll have seen this before. But this was created in response to the need to strategize over how to respond to the BC Treaty process. And these highlight, in particular, the concern that the process is not founded on the basis of recognition of existing Aboriginal rights, including title. So you'll see the concerns listed, that negotiations are not based on a connection to territory, that no determination of boundaries must occur before negotiations begin, and no requirement being made to negotiate with a proper title holder, and so on. The following items as well are connected to concerns about the process not being theoretically or practically consistent with a rights recognition approach. And in particular, the need for alienation of Aboriginal title through extinguishment, surrender, and modification, being contrary to the constitutional protections in Section 35, that being built into the process has been objectionable since the beginning of this treaty engagement with the province and Canada. So UBCIC's critique of the BCTC process has highlighted these concerns throughout, through this 25 or so year process. And the concern is that they show what happens when you have a process based on a faulty theory like extinguishment or non-recognition, that it sets things off on the wrong path and doesn't result in justice or certainty, which are often the stated objectives of this type of process. So looking to the discussion paper, which has been circulated by the province, I'll just go over it very briefly. It's a very brief document. But the purpose stated for the document is to facilitate discussion with First Nations within and outside the treaty process in the spirit of free, prior, and informed consent. And of course, those are good words and principles. As you review the document, it's not entirely clear how the principle of free, prior, informed consent will animate the proposals that are developed going forward, and that's one of the concerns going through it. The context is identified that the treaty process has generated for treaties resolved since 1993, and there are more in negotiations. But the context also shows that the province is committed to the treaty process as being the most complete mechanism available for resolution of a relationship between the Crown and First Nations. The document also identifies the principles for transformation, and again, these words are very good principles. The recognition of rights and title, the concept of self-determination, and they're generally not objectionable. Flexibility, of course, is important, but still it's not clear in the document as it stands, and of course it's a rolling draft, so it's a discussion paper to be developed, but it's not clear how these will operate to animate what has been called a transformation. The document then goes on to itemize some proposals for transformation, and as I said, this is for development and discussion. But the concern about these proposals is that they're not specific or concrete, such as that they can be truly understood to achieve something like transformation. Of course, again, what's identified are important and key concepts. The promotion, retention of Indigenous languages, the improvement of socioeconomic outcomes. These are vital concerns. But the document doesn't identify how that, in practical terms, may be carried out. One notable thing about the proposals is that they're confined to the treaty process, and so they don't address other forms of Crown engagement. It's clear that the transformation under discussion is an adjustment of the existing process, not a change from the BCTC process into something conceptually or practically transformed, distinct. So the paper concludes by seeking input. Now, this invitation to give input wasn't formally conveyed to UBCIC, but this is nonetheless an opportunity available to say, for the UBCIC and for yourselves to say what treaty transformation could look like, an opportunity to provide your significant experience and wisdom on the subject. And in doing that, some of the key issues that may be worth responding to include the issue of being fixed on the BCTC process as the baseline for treaty making or for resolution of the question of title or Indigenous rights to lands. One thing that I note, and having heard Chief Judy Wilson's presentation this morning, is that it's not clear how the proposals identified in this document are married with or are consistent with or how they work with the commitments that are made in the documents in 2015 and 2018 that set out a new way forward for Crown Indigenous relations. There's also nothing in the discussion paper about nations who are not within the treaty process. And so it says nothing about recognition or implementation of those who have not engaged, but it also says nothing about those who are signatories to Douglas treaties and how those nations' rights will be implemented in a manner that's consistent with their Section 35 rights. Again, issues to respond to include a central concern, which is that the discussion paper does not address how boundary issues can or will be addressed in concrete and well-resourced ways. It doesn't consider how to address boundary questions in particular where those arise in ongoing negotiations. So where there are groups that are already in the process and underway, how will a transformation of the existing process achieve justice for neighboring nations of those who are seeking treaty and have prepared a statement of intent for their area? So fundamentally, one of the concerns is what real differences other than good terminology and good intentions will create a meaningful change in what the UBCIC has identified as problematic aspects of this treaty process founded in a model that does not recognize rights. So again, the proposal, the recommendation that is being made, that I'm making, is to respond to the discussion paper with your collective wisdom and experience, to address the fact that the paper does not propose bold, concrete action or true transformation, and that in failing to do that at this stage, it does not significantly advance reconciliation. So to that end, the recommendation is that the UBCIC provide comments to the province to describe the union's concerns and identify that without more, this will present a lost opportunity to do meaningful and significant change in the process. This is on the basis that after the court's conclusions in Delgamuukw and Tsilhqot'in, the relationship with the Crown has to transform on a legal basis. An approach based on title just being a theoretical concern can't be part of the modern Indigenous-Crown relationship. And I understand that UBCIC has been prepared to work collaboratively on these issues and to generate options for rights recognition in keeping with a true government-to-government engagement. And as such, this effort would be consistent with the UBCIC's goals in bringing these issues into a more modern and more productive and just framework with the Crown. And on that basis, the recommendation is for a resolution that UBCIC will respond to the discussion paper to emphasize that the changes are not sufficiently responsive to significant and ongoing concerns that have been repeated since before the treaty process was commenced. And on that basis, I've sped through my comments in order to make sure that there's lots of time for people to react.
Thank you, Aline. And opening up to questions and comments, perhaps starting with just a quick explanation why this is aimed at British Columbia, given Canada as a part of the BCTC as well.
Oh, so I think because BC has independently prepared this discussion draft to realign the relationship of its own accord. And I think with the change in government and with engagement with stakeholders around that time of the change, wanted to move forward with those aims, separately from Canada.
Good. Questions and comments? Any questions or comments? Mike 5.
Cookby Christian, Splatsine. And I guess the resolution that's coming forward, is it in the package? It is. Okay.
second
Did you? I haven't looked at it. Has it also addressed the Organization of American States, the Declaration on Indigenous People? Because we always talk of UNDRIP. There's also that resolution. Has that been incorporated into it, or any discussion on that at all?
It basically says it's not in line with the declaration.
Okay, just that one, the UNDRIP, doesn't talk about the other one, right?
Doesn't mention the other one, no.
Okay. The other thing, nation-to-nation treaty, and again, there's the whole history is around, the Royal Proclamation of 1763, and then the Treaty of Niagara in 1764, et cetera, right? As in terms of, treaties as we understand it, and that's, again, our oral history. So this process, I always said it was never a treaty process. It was more about real estate. They were buying up land is what they were doing. There was actually real estate agreements. They were buying land and certainty for land. The question I have, I guess, in the recommendation is how do we deal with the Crown? Because they, as the Crown, under these obligations, have never followed the rule of law, constitutionally, Section 35(1), et cetera. So how does the recommendations we're making on this process deal with that part of it? Because the Crown has come in and interfered with our nations by using this process. And, interfered with us working together and made fractures that may never be repaired in our lifetime between our people. Created division amongst our people by using our friggin' law again. And it's supposed to be a political process? That's bullshit. It's not a political process. It's a rights-based process. Once you try to challenge it, you can't challenge it till after there's a final agreement. The whole process stinks. So I guess my question is, how do we bring the honor of the Crown into the discussion? Because that's what's going on. The Crown as represented by British Columbia and the Crown is represented by Canada. So how do we hold them accountable for all what they've done over the last 30 years? I think it's really, because that's the issue, because they've created fractures amongst our nations, and that's what they've done. So how, in the discussion and our response to the province and Canada, do we deal with that part of it? Because that is the fundamental issue that's wrong with this process. It created division amongst our families.
Christian Cookby? Any response from 22? Mike 22?
Thank you so much for your question, and I'll give a very brief answer, but there's probably many more people in the room who have a substantive contribution. From the perspective of the legal strategy world, there's diplomacy, negotiation, and litigation. And in each of those spheres, I think the principle of the honor of the Crown and the rule of law, which means the implementation and the respect for our Constitution and your Section 35 rights, are at play. So in terms of diplomacy, which would be a written response commentary, I think all of those subjects should be addressed. If you were pursuing negotiation, the same. And if you were pursuing litigation, arguments would be grounded in those theories as well.
Any other questions or comments? Mike 20.
Thank you, Mr. Chair. Cheryl Casimir, First Nations Summit. As many of you know, the First Nations Summit is an organization that represents the interests of those First Nations who are pursuing the negotiations process through the Treaty Commission, the BC Treaty Commission process. And I just wanted to note, and I think it should be known for the record, that the First Nations Summit Executive is also putting forward comment and has put forward, correspondence outlining some of the concerns and some of the shortcomings that we see as well. As a principle to this process, in partnership with Canada and British Columbia, we endorsed a multilateral engagement report to improve and expedite negotiations in BC. And this BC Transformation Initiative is contrary to what we've agreed to, given that principals need to address these issues and shortcomings on a tripartite effort. British Columbia unilaterally developed this paper and tabled it with the chief negotiators. The chief negotiators have addressed some major concerns related to that, and we're on record wanting to make sure that for example, rights that are not addressed in a treaty agreement or other constructive agreement continue to exist. Treaties, agreements, and other constructive arrangements will not exhaustively enumerate, replace, or modify existing Aboriginal rights. First Nations have the right to implement their inherent Aboriginal rights, and the exercise of rights outside of a treaty agreement or other constructive arrangement cannot be contingent on an agreement with the Crown or a court declaration. And those are just some of the key issues that we've raised. We also talk about how Section 35 is a full box of rights, or represents a full box of rights. We still need the province to support that notion. The federal government has come forward in their 10 principles stating as such, and we know that the province also prepared 10 principles mirroring what the federal government put forth, but stating or acknowledging that Section 35 is a full box of rights seems to be missing from theirs. But I just wanted to share with the delegates on the table that as a principle to this process, we have prepared submissions to both British Columbia and Canada, letting them know what our issues and concerns are related to this paper. Thank you.
Thank you, Cheryl. Mike 5.
Yeah, thank you. Yeah, this issue of BCTC process hits home. I got a letter from federal and provincial governments wanting to consult with me to see if what I have to say about the treaty process that's going on within some of the communities within the Shuswap Nation. And and I don't know how they arrived at this. They said that by our assessment, your title and rights is minimal in this area. It's low to nothing. So how do they arrive at that? Who tells them that? And not only that, they violate our Secwepemc law because our chiefs in 1910, and this is the chiefs of the Syilx and Secwepemc and Secwepemc. This is what they said, and this is what they wrote down. The real whites we found were good people. We could depend on their word, and we trusted and respected them. They did not interfere with us nor attempt to break up our tribal organizations, did not try to break up our laws and our customs. Our laws and our customs. They did not try to force their ideas of things to us to our harm, nor did they stop us from hunting and fishing and so on. They never tried to steal or appropriate our country, not our reserve lands, or areas of interest or things, but our country as a whole, all of Secwepemc, 180,000 square kilometers. And treated our chiefs as men. They were the first to find us in this country, and we never asked them to come here. Nevertheless, we treated them kindly and hospitably and helped them all we could. When they first came amongst us here, there were only Indians here. They found the people of each tribe supreme in their own territory, having tribal boundaries known and recognized by all. In other words, we recognized and respected each other's boundaries and upheld them. The country of each tribe was the same as a very large farm or ranch, belonging to all the people of the tribe from which they gathered their food, clothing, and so on. And they go on to say, all the people had equal rights of access to everything they required. You will see the ranch of each tribe was the same as life itself, and without it, we could not have lived. And this is, this is with the position that we had as a Secwepemc nation back then. Now the government's coming in saying that I wrote to them and they said, well, it's not a rights-based process. It's a political process, so they're using that to circumvent, the Supreme Court rulings on our rights. They're using that to circumvent Section 35(1), the Constitution. They're using that to circumvent UNDRIP. And what I see it as is it's none other than a reenactment of what I call the McKinnon-McBride Commission, in which they herded us onto reserves and claimed all our lands are outside the reserve boundaries. This is a new, given them more certainty over that. It's a 5% solution. You only get 5% of your lands. The province collects 95% of that land. That's a land grab. This BCTC process is nothing but a land grab, and we're allowing it to happen. I don't know why we're allowing it to happen. We ought to be standing up together and saying no to this process. We have to get back to a proper approach on nation-to-nation, principled, proper nation-to-nation process so that we can arrive at an honorable place. And, and the chiefs went on to say that, instead of treating us this way, when they became more and more powerful and we weaker, they set aside many small reservations for us here and there over the country. And nowadays they call these little reservations First Nations, that they're using to negotiate treaties with as First Nations, because they have a named nation in there. This was their proposal, not ours. They said it's not our proposal. We never accepted these reservations as settlement for anything, nor do we sign any papers or make any treaties about the same. They thought we'd be satisfied with this, but we never have been satisfied and never will be until we get what is our rights. That's where we ought to be going with this process. We have laws in which we've negotiated treaties with our Nsilic nations, correcting the boundaries between us, reestablishing boundaries between us. We've had a number of treaties like that. We have nation-to-nation relations. There's no such thing as overlap, as the way they explain it according to this process. We have laws that govern our relationships. Those come under our laws. It's not helter-skelter, just overlaps. So that they don't know us, and they're trying to impose a system on us, again, recolonizing us in the modern way. And that's unacceptable. They have to step back, and they don't know us. This is why I took the time to write this book. So Secwepemc People, Land, and Laws. And that's what they need to understand. They've got to understand us in the way we explain ourselves, not according to how they think we are and who we are. Thank you.
Cook Chairman Cookby, Mike 17.
Barton Lewis, Chief of the Okanagan Band. I often wonder about this whole BCTC process, because if you read the British Columbia's Terms of Confederation, which they joined Canada with, that there is a number of what they actually agreed to. And if you read Section 13, it says the charge of Indians and the trusteeship and the management of the lands reserved for their use and benefit shall be assumed by the Dominion government, and policy as liberal as that hitherto pursued by the British Columbia government shall be continued by the Dominion government of Canada after union. Then it goes on to say, to carry out such policy, tracts of lands to such extent as it has hitherto been the practice of the British Columbia government to appropriate for that purpose shall from time to time be conveyed by the local government to the Dominion government in trust for the use and benefit of the Indians on application of the Dominion government in case of any disagreement between the two governments respecting the quality of such tracts of land to be so granted, the matter shall be referred to the decision to the Secretary of State of the Colonies. When you read that, what is exactly the reason for a treaty if you're giving up title and rights when it says under the terms of confederation that that process is supposed to be ongoing, allowing for periodic reviews of policy based upon existing policy today? Now in the interior, if you look at the tracts of lands that were set aside, you know, they're considerable. You know, in those instances, does that mean that the policy should be reviewed and looked at those reserve lands and those increases based upon that policy? Because that's what it says. And if you look at some of the other instances, so why are we, you know, anyone would even contemplate a treaty when you have that obligation that's a part of the constitutional law of Canada that they're supposed to do anyhow? Why are we in a process to where, you know, it shouldn't cost you a dime? It should be that you make an application to the Dominion government. They in turn petition the province of British Columbia. A joint review happens between the two, and then it's determined based upon previous policy and procedures that additional land would be added to your reserve. And that happened twice. 1877 under the establishment of the joint reserves in the interior British Columbia, and again in 1911. Even though it was reduction, there was also additions to reserve lands. So, you know, why aren't we asking that question? Thank you.
Lieutenant Chief, being cognizant of time, we have a hard stop at 3:30. We'll continue this discussion when the agenda comes to the floor Thursday morning. So thank you, Aline, for your presentation. Oh, sorry, when the resolution comes to the floor, not the agenda. So next we're talking about specific claims, additions to reserve policies, objectives. Inviting Jody forward. I'll give a quick update on specific claims. And then we'll have Susan Waters, who is the Director General Lands and Environment Management from the department. We'll talk about the additions to reserves. Mic 22. Susan Waters in the house? Yes, come forward, please. She doesn't have a presentation?
Yes.
If you have a presentation, sit over here so you can see the screen. On the corner. There's a monitor there. You can see your presentation now.
Okay, thank you.
Who's starting, Jody? Mic 22.
Okay, thank you so much for your patience. So first of all, I'd like to acknowledge to Kamloops Band, I'm sorry if I said that badly, for hosting, and acknowledge we're doing this work on Secwepemc territory. Thank you very much for having us. If you just want to refer to tab 8, I'm just going to give a really quick 5-minute update on claims and then yield the floor to our guest. And really what I wanted to focus on was the discussion around an independent claims process. So I brought this up for the last couple of meetings, and then at our last meeting at ADM, Joe Wild was here, and he assured delegates here that he was committed to working towards an independent specific claims process, and that the minister stressed the importance of developing an independent process to Prime Minister Trudeau in a recent Take Stock meeting, so that would have been back in June, and that the minister strongly recommended submitting a memorandum to Cabinet in the fall seeking authority to move forward on this. Right now, we don't have any word on the status of that memorandum to Cabinet. If it goes through, what would likely happen is that the AFN would receive funding to begin holding engagement sessions across the country so that nations themselves could define what that independent process would look like. There's a lot more information in your kits, and then I'm just handing around an at-a-glance kind of document for you that highlights some of the things that are in your kit. And then one more quick bit of business to take care of is that there's a piece of legislation called Bill C-58. It's amending the access to information legislation. And there are a lot of parts of this act that are going to make it more difficult for Indigenous nations to access materials to research claims or participate in any kind of historical research for their communities. So we just secured some funding from the Treasury Board Secretariat, who to this point haven't consulted First Nations on this bill, in order to carry out a legal review. And we've contracted Bruce McIver to carry out that review. And in fact, I just got a draft across my desk a few minutes ago. And so we're having a look at that. But one of the things that we wanted to do was try and create some kind of way for the people who use access to information regimes to provide feedback. So we created a survey, and there's I don't know, 10 or 15 copies of a page up at the front desk. It's bright red with the survey address, URL on it. So if you at all participate in that process, if you ever do access to information requests, please go grab it and take a few minutes to fill out the survey. It was originally like an hour, we made it 15 minutes, so it's not too bad. Okay, so I'm just gonna turn it over to Susan Waters, who's the Director of Lands and Environmental Management at Crown and Indigenous Relations Canada. Did I get it? Director General. Okay, thank you.
Okay, well, thank you very much, and good afternoon. I wanted to honor the traditional territory of the Squamish. I'm sorry I'm saying that incorrectly, so Squamish. Sorry. I've been trying to get it right, but I will promise to do that shortly. Anyway, I'm just very honored that you've given me some time today to talk about proposed changes to the Additions to Reserve process. I am a Director General for Lands and Environment. I work in Lands and Economic Development at headquarters, and I'm here with Catherine Blair, who's the Manager of ATRs in BC Region Office. Just as a short summary of introduction, I manage programs to support First Nations on lands and environment, including lands administration under the Indian Act, Additions to Reserve, First Nation land management, management of real property, Reserve Land and Environment Management Program, and also some environment programs related to waste management, contaminated sites, and environmental review. So I am very happy to follow up with questions by email or phone call if you have the need to inquire about other aspects of those programs. So I've got a presentation, and is it? Okay, thank you. So do I control it, or? Yeah. Okay. All right. Oh, I think I'm okay. Okay. All right. Anyway, so I have a short presentation to outline some of the proposed changes. Anyway, as everyone knows, the Additions to Reserve process is a very important process for First Nations Through the additions to reserve process, we are fulfilling legal obligations by treaty land entitlement and settlement agreements. We know that they provide access for community lands and resources and increase community and economic development for First Nations. Currently, there's about 8.8 million acres of reserve land in Canada, but we know that we owe at least 4 million acres through treaty land entitlement and settlement agreements. And right now, 1.3 million acres are currently actively being processed. 80% of all additions to reserve in the last number of years have been for legal obligations. And interestingly enough, we're finding that more and more additions to reserve are urban. And since 2015, we've actually quadrupled the amount of additions to reserve that are urban that are being processed. So now about 10% of all urban additions to reserve are urban. So I just wanted to outline some changes that we've been involved with First Nations to improve the additions to reserve process, acknowledging that it is a very cumbersome, complex, and lengthy process that does take way too long. But in 2009, the department worked with the Assembly of First Nations, National Aboriginal Land Managers Association, and others through a joint working group on additions to reserve to improve the additions to reserve process. And there was quite a lot of engagement at that time. I'll just outline some of the engagement. Over the next 4 years, from 2009, the working group reviewed options for renewed and improved policy directive, and in 2013 a public engagement process including outreach to First Nations, provincial and municipal governments. 19 First Nation organizations representing over 150 First Nations participated, as well as the First Nations Lands Advisory Board, National Aboriginal Lands Managers Association, First Nation Tax Commission, and others provided written comments. There were regional workshops and technical discussions were held over the following 2 years. And then in early 2016, there was re-engagement with the Assembly of First Nations and other key stakeholders. And on July 27, 2016, the new Additions to Reserve Policy Directive took effect. And since that time, we've been working in very close collaboration with NALMA, the National Aboriginal Land Managers Association, to provide training and overview of the new policy. So I thought I would just outline very quickly the changes in the new policy directive. It provides an updated framework for assessment, acceptance, and implementation of the additions to reserve proposals. It clarifies roles and responsibilities of all parties and outlines a process for better collaboration between all affected parties. And it establishes a new category for addressing ATRs pursuant to specific claims tribunal decisions. There's more flexible environmental requirements based on intended use rather than requiring all land to be free of contaminants. So for example, if a land is intended for industrial use, a standard of cleanup to industrial standard is acceptable under the new policy. And there's also more flexible land selection area. So I just have the amounts that have been approved since November 2015. And you can see in BC region, there's been 15 submissions approved for a total of 970,000 acres. So we knew that when the policy directive was approved that it was only one step along the way. As many of you know, it's a very complex process. And we still have ongoing challenges and ongoing issues identified with the current process. We know that lack of access to pre-reserve designation outside of the Prairie provinces for treaty land entitlement and settlement agreements creates quite a problem for transferring land that has targeted for especially economic development. There's also challenges with addressing third-party interests before reserve creation, which leads to delays, uncertainty, frustration, and lost opportunities for First Nations. We know that, as I said before, there's more proposals for urban reserves, and those tend to be more time sensitive and requiring additional features. And then we also know that the lack of core capacity in First Nation communities, lack of appropriate program management tools and resources for land surveys, environmental studies, et cetera, can be a real hindrance to additions to reserve. So I just have on the map the number of active additions to reserve by region. Those are the ones that we validated with First Nations that they are still priority additions to reserve. So in BC, we have 68 that are currently considered active. So I wanted to introduce you to the Claim Settlement Acts that are in place in the Prairie provinces. They were enacted to fulfill agreements to settle the land debt owed to First Nations still owed under historic treaties and to support the implementation of settlement agreements from specific claims. So First Nations that are adding land outside of the Prairie province do not have access to these legislative benefits. So benefits of these acts, there's about 4 key benefits. So the additions to reserve under these pieces of legislation are approved by ministerial order rather than order in council. Currently, ATRs in BC have to go to, for Governor Council approval, which means that they have to go to the Treasury Board, and that can add quite a few weeks, a lot more to the approval process, and in some cases a couple of months, because it depends on the priorities or the schedule before the Treasury Board, and also the meetings that are scheduled for Treasury Board. So the submissions that are going to the minister are approved much quicker because they don't need to go through that extra step. Also, under those pieces of legislation, the First Nations are able to address third-party interests before reserve creation, and so they're able to more smoothly transfer those interests to reserve. Access to pre-reserve designations, so land under the Indian Act needs to be designated before commercial leases take effect. Right now in BC, that process has to take place following reserve creation, which can add 18 months, 2 years to the time period for an actual lease to be properly implemented in that area. And then the ability to put in place pre-reserve leases and permits can come into effect upon reserve creation. So the proposal, which is not a new proposal, but it has been identified through the number of years, and we even have a resolution from the AFN from 2012 that talks about nationalizing the claim settlement legislation to have it apply across Canada. So we're looking there's a window of opportunity, a possibility that the legislation can be introduced that would bring the application of these 3 pieces of legislation across Canada so that all First Nations that are adding land to reserve would benefit from these efficiencies. There's also some additional efficiencies being considered which would allow the minister to approve easements and voluntary land exchanges rather than having to seek order and council approval. And so the idea is to create a nationally consistent approach that wouldn't have distinct benefits in some parts of the country, but all First Nations would benefit. So again, the anticipated outcomes, having the same benefits across the country. We hear that having access, the First Nations that have access to these are able to provide more commercial certainty with respect to the continuity of third-party interests, and then able to also obtain appropriate financing, knowing that the work can be done ahead of time and take effect upon reserve creation. And it's extremely important with the selection of economically viable development lands, increases opportunities for future development, and supports the development of healthier, more sustainable communities. So we're seeking your feedback, and letters went out last week to all First Nations. I don't know if any of you hopefully have received them. They went out by email, and they're following up by Canada Post to provide some notice of these changes. And they're part of a larger scale lands modernization initiative that would support First Nations in being opportunity ready. And so we know that there needs to be more work done with reserved land. We know that there's a lot more need for capacity for land management, better tools, and an approach that would take First Nations out from under the Indian Act in a more holistic and transformative way. And we know that conversation will take some time. Here's an opportunity to make some incremental changes. They're optional opportunity. First Nation has their discretion of whether to use these tools. They can continue along the same path, but from our understanding and comment and feedback that we've received, these would be considered to be quite welcome. So I don't know if I have time, but I can just quickly go through a table at the back. I know it's not very large, but just to show you again the administrative technical changes. Ministerial approval versus Governor and Council approval is the first band of changes. And also for those are for additions to reserve, and also for voluntary land exchanges where one or more parcels are required to be added to reserve in exchange for removal of some land. And we see that in some provinces where there may be a provincial road crossing a reserve and the First Nation receives benefit for the land, and then a complementary parcel of land is identified to be added. And so all it does is the First Nation, is up to them to approve the voluntary land exchange, but the minister can sign off on that according to the proposed changes rather than going to Governor and Council. And then the pre-reserve designation, which I spoke about, that would be extended to all First Nations across Canada, pre-reserve leases, pre-reserve permits, and that's it. So I don't know if you want me to take a few questions, or I don't know how you want to
Before
proceed.
we open it up, go to Cookby at mic 23, but recognizing we've got 10 minutes left on this topic. 23.
Waikaikaitep, Chief Judy Wilson. I'm chair of the BC Specific Claims Working Group. And I just wanted to acknowledge my co-chair. Where did he go? Oh, there he is. Chief Dalton Silver, hardworking guy, and he's going to do some presentations on our behalf in Halifax. It's supposed to be a co-presentation, but Dalton can cover that. Anyway, I wanted to say with BC Specific Claims that Jody presented out, it's really important for the work that's being undertaken on the call for independent tribunal. It's been long outstanding, so we're hoping to push that forward. And I also wanted to say there has been only some statements from the federal government saying that they were going to do away with the comprehensive claims policy and specific claims, but they're not clear what does that mean. Under the recognition and rights implementation framework has not been specified what that means. So we've asked, when Joe Wild was here, we asked Minister Carolyn Bennett. That's not being very clear. So we do have a presentation that I'll be doing on October 12th at the National Research Directors Conference in Halifax. That's why I had to split my day out from Dalton to do a Friday presentation on that subject. And I just wanted to say what's exciting on BC Specific Claims is the work Ardith Walcom's doing on Indigenous laws. What would it look like in specific claims with a process through our Indigenous laws? And I think Cookby Ron talked a bit about it already, what it would look like through our Indigenous laws. And the other one is the outstanding closed claims. When they mean closed claims, doesn't mean they're settled in no way, shape, or form. It's got to be. We've been going through them. What does that mean? And they're all outstanding, fairly claims. And then also the Canada's conduct at the Specific Claims Tribunal. So that was the other project that we did. And I just wanted to say with the additions to reserves with Susan Waters, I did see a presentation. I think it was. Chiefs Committee on Claims, Territories and Lands a few weeks ago. And one thing I noticed there, what I was explaining to her was in BC we have something called the land selection process. So when you're doing your additions to reserves, they narrow it down to very small parcels because they say, oh, that's spoken for, oh, you can't have this land or that land. So the land selection process in BC hinders the additions to reserve process. And then with additions to reserves, I think how many were processed? 15? And then there was like 65 in process now, or some submissions, I guess. So anyway, it tells you that there is needed change around that. So I'm hoping a lot of your comments and questions will be focused on, you know, what those changes are needed. I know in our community we've had outstanding additions to reserves and transfers, highway transfers since 1951. So many of your reserves I know have outstanding additions to reserves as well. So I'll just end on that. Thank you.
Thank you. Mike 10.
Well, Chief Clarence Louis from the Sioux Singing Band. The issue of ATRs, I think, are one of the most important issues that we should be dealing with. some of this stuff, like Hazel brought up earlier, there's no end in sight to it, some of these issues. I think our grandkids are going to be here 50 years from now dealing with some of the same stuff. But the issue that I want to bring up that we can get the government to focus on, and they can do it. There's no research needed to be done. There's no lawyers that need to be hired. And Ron mentioned it. The McKinnon-McBride cutoffs, where the province is in control of our old reserves. I'm talking about our old reserves that were originally established. Those lands should come back to us. There's no research needed. There's no long negotiating table needed. My message to this government is true reconciliation has to start with the land. Not with apologies, not with flying our flags at municipal halls or standing there at every meeting saying those good gestures. That's all they are, is good gestures. They don't create one job on the res. They don't bring any income to any of our reserves. Yet, we should be starting with getting our old reserves back. There's no research needed on that stuff. We don't need to hire lawyers. We don't need long negotiating tables. If they really believe in reconciliation, our ancestors, their ancestors, however it happened, those boundaries were there. The old reserves are easy to find out. I know at Osuyus, I'm telling government, reconciliation starts with us getting our old reserves back that the province still, right now as we sit here today, have under their control. And every reserve should originally get back to its original size. At Osuyus, we're about 4,000 some odd acres short of what our reserve that was established in the 1870s was set to be. So to me, that's where reconciliation starts, is getting our old reserves back and getting the reserves back to the original size that's documented, fully documented. That's my message to government, and I hope the union and all the other bands in this province push for the same exact thing. Limlimt.
Limlimt, Chief. Mike 7.
Thank you, Mr. Chairman. First of all, I'd like to acknowledge the Kamloops. Thank you for allowing us here. Maureen Chapman, Hereditary Chief of Squelch. And I want to speak to the specific claims and a letter that was distributed dated July 6, and want to know if you've received any response from Minister Bennett. And I guess launching off of Chief Louis' comments too, we've heard this year after year after year that we're going to do something. And Joe Wild has said that he wants to move this along, remove the bureaucracy. Well, the bureaucracy hasn't moved one iota. We are currently involved in a specific claim that we have hounded and called meetings and hand-delivered letters to Minister Bennett, Joe Wild as well. So what is our recourse when they're not making any movement on their promises and commitments to this process? Thank you, Mr. Chair.
HKCM, Mike 5.
You know, and when I did looked at the McKinnon-McBride Commission, and I could be wrong, but one of the things that I understood that occurred out of the McKinnon-McBride Commission was that the province negotiated with the federal government reversionary rights interests in our reserve land. And if you look at 6.1, 6.2, they're moving us that way to become extinct as status Indians in a way, so that those lands could revert back to the province. What I think that I'd like to see the union do is to commission a paper to take a look at, instead of enhancing the ATR, we fight so hard for additions to our reserves, and that's only going to revert back to the province in any way down the road. What we should be looking at is a way that we can have our own indigenous land registry, so that we can register our collective title lands there Because the only place that you can, if you have a settlement of some kind, a title settlement, the only way that you can place that I understand that you can register it is with the provincial land registry, and that's why those BCTC lands are now being transitioned into fee simple lands, because that's the only way that the provincial land registry could recognize them. And we need to move out of that and establish our own land registry that recognizes and maintains the integrity of our collective rights. And I would like to see the union move in that direction so we could transition out of this ATR process and into that. Thank you.
Cruikshank Cookby, Mike 17.
Byron Lewis, Chief Leo Okanagan Band. You know, one of these, what really bothers me on this, some of this whole question is this, you know, rights of resumption by the province saying when a band goes extinct that they are the rights, they are the proper property holders of that. But when reserves are set aside, it was based upon nations, and if there's any type of extinction of a band in the future, that land should actually go back to the nation, not to the province. They do not have any rights whatsoever to make that claim. And that's something that we should also be really pushing, because, you know, you look what's happening now with this whole thing about status, you know, because, you know, eventually it could be like there's some bands in Ontario that are one marriage away from losing their whole entire reserve. We don't know what the future is, but I would say that at those times when those instances do come up, that those lands should go immediately back to the nation and not to the province.
Limnum Chief, responses, concluding remarks, Mike 22.
Well, anyway, I thank you and acknowledge some of the frustration with the ATR process, and I know that acknowledge that this is not going to dramatically change the process. It's an incremental step along the way that will facilitate a certain type of additions to reserve. We are very much engaged and committed to improving the process. We're looking at railway takings right now to see if they were part of the reserve land and taken, should they not go back to reserve, and an abbreviated process. And I appreciate that for all lands that were originally reserve lands. So to say that this is not the end of a renovation transformation process, it is just one step along the way, in that we're very much open to hear and understand opportunities to further address the ongoing reconciliation of land and some of the unique challenges that are here in BC.
And just to respond, Chief Chapman, we haven't received a formal response to the letter to the minister. At the Chiefs Committee on Lands, Territories and Resources, there was some talk of this being a priority. The only response or sort of high-level word we've heard on it was what ADM Wild said at the last meeting here, which was about how committed they are, et cetera, et cetera.
Thank you. Just before moving on, a quick comment, Mike 16.
Dean Nelson, Lillooet. Just a quick question. Both ATR and specific claims, loss of opportunity, you know, that we're in specific claims and it takes years to get it settled, but you know, what happens in between there? We never have an opportunity to get the lands back that are in question here, so that's all I'm saying, is the lands in the ATR and in specific claims. So, thank you.
Thank you, Chief. I'm under the gun here. We have the women's representative coming up next, and we have a short stop. Mike 19.
Why is Question Killock Jean? I just want to reiterate the 1871 Terms of Union and the whole reason why BC didn't join Canada in '67 in terms of the recent Williams Lake Court decision. I think that's a really significant point to make and ensure that all things considered, that title does exist. beyond this colonial structure process. So you want to resolve land questions? Let's talk about the real truth behind the land question.
Limnam Chief, can we leave this topic this way? Your questions weren't really responded to very effectively by the federal officials, so perhaps Jody and Cookby can work on capturing your questions and comments, put it in a piece of correspondence to Susan, and she can more formally, or somebody can more formally respond to your questions and concerns. With that, thank you to the presenters. We do have to move on, inviting forward Tijuanit, Elaine Alec, for a women's representative update. Two things. We do have the hard stop at 3:30 for the photo opportunity. Cookby Christian and his colleagues are going to have a formal honorary song before we leave the building for that picture. And just a respectful reminder to everyone here, delegates and guests alike, when it comes to the Women's Representatives update, you as a body demand your full attention to the updates. I encourage you to put your phones down. Don't be looking at your phones when Elaine is providing her update. It's been that way for us for about 3 years now, and it's a good place for the union to be, to ask for your full attention on such an important topic. Mike 3.
Wai chasgahal tlachach lahap slachlach di sin ksilch in chai squeeze teeth kanit kinokanakin sichwapm. Good afternoon, family, friends, elders, Ilmichum, leadership. My name is Teeth Kanit, and I'm from the Okanagan and Shuswap nations. My name is Elaine Alec. My late father was Saul Kenzie Basil from the Bonaparte Indian Band, and he was the son of Saul and Louisa Basil. My late mother was Sophie Alec. She was the daughter of the late Chief Jack Alec and Eileen Alec. I am the proud mother of 3 children. My son, Kyle Windwalker Alec, he's 23. My 8-year-old daughter, Phoenix Eileen Alec, and my 10-month-old son, Teslin Pelkamulach Alec. Thank you all. I first wanted to thank everybody here for creating space for me to have my son here. He's really loud. I also really appreciate the elders that I was sitting beside earlier. I was trying to chase him down, and one of the elders said, "Leave him." And it reminded me of my grandmother and the way that I grew up in meetings. And I always felt really safe sitting by my elders, and I always listened to them. And as soon as I said that, I walked away and sat down, and my son sat right in front of them, and he was totally content. And before that, he had been all over the place, and he couldn't stay still. But as soon as that moment happened, he settled down, and he went and sat by their feet, and he played, and he was calm, because they created that space for him to be here. And I think that's a huge barrier for a lot of women who want to be involved in important discussions like this, especially young women and mothers. We have a strong voice, yet we don't always feel safe, and we don't always feel welcome to come into these places, especially when we have children. So I really want to take the time to thank you for creating that, because I believe that my children hear everything. My children have been coming to meetings. My son's been coming to meetings with me for a very long time, and they pick up everything that they hear. And when I was a little girl, I grew up in these meetings as well, and I was mentored by many of the leaders that are sitting at this table, and they told me how special I was, and they let me know that I had a voice. And because of that, I'm able to sit up here and speak to you and know that I have a voice, that I am powerful, and that I am a strong Indigenous woman. And that's not, not a lot of our people, especially not a lot of our women, can say that. And so I just wanted to take some time to say that. This past year and a half has been a bit of a struggle for me in this position. It was a surprise to end up in this position. I was overwhelmed and emotional, and I continue to be overwhelmed and emotional. And I started feeling a lot of anxiety as this meeting was coming up, because I felt so much anger and heartbreak and pain for a lot of different reasons. But I prayed really hard leading up to this meeting because I didn't want to come out angry. I wanted to come here and speak with words that would be heard, that people wouldn't shut off their ears to some of the things that I needed to say, because some of the things that I needed to share from the things that I've heard might not be popular, and some people might be uncomfortable with that. But I think if you've been paying attention to the news, I think it's really important, and it's time for people to start getting uncomfortable. Because if we don't do that, and we don't acknowledge what's really out there, then we can't change it and we can't heal from it. I've been praying a lot for a lot of our women because of the things in the news lately, all of the sexual assault cases that are showing up in the news, a lot of the women who are being disregarded and displaced and ignored. And it's affecting, everything that's out there affects everybody. And at the same time, you know, as the women's representative, some of the work that I've been doing is creating safe spaces for women to come forward. And we're looking at different policies and how to do that. And we started talking about indigenizing. And I really don't like that word, indigenizing. Because when I hear the word indigenizing, to me, it's looking at a colonial system or a system that we've adopted from other people, and we're just trying to put Indian things into it. And it doesn't really belong to us, and those systems continue not to work for us. And from my nation and where I come from, we come from an egalitarian society. And so all of our voices are just as powerful. The men, the women, the youth, and the elders. And so, you know, a lot of the things I've been hearing is that women don't feel like they have a place at this table, and they feel like they don't belong. And it's not just this table, it's all tables that are set up based on systems like this. Power structures. And I think about how can I communicate to men what that feels like. And I think our men know what that feels like because you're Indigenous men and you deal with racism and you deal with a racist government that treats you like children. And so you take that feeling, and that's what it feels like sometimes sitting there as a woman trying to be at the table, is that it feels like we don't always belong here. We had a women's meeting last night, and we had about 60 women come together. And we based it loosely on our Anaukinwich process. And what we did was we self-identified into 4 separate groups based on our decision-making or how we make decisions or our perspectives. And those 4 perspectives are the innovative thinkers, the ones that think outside the box, the action thinkers, the ones who just want to get the work done, the traditional thinkers, the knowledge keepers, the ones who like the structure, and the relationship thinkers, the ones who don't want to leave anybody behind. And we broke out into groups and we talked about some different ideas, things that we wanted to talk about that were important to us. And the number one thing that came from all of us was healing. Healing was the number one thing. So healing for individuals, healing for families, healing for communities, and healing for the land. But another thing that was really important to the women there were that you know, just because we're women doesn't mean that we're only coming to the table to talk about women's issues. We don't just want to come to the table to talk about MMIWG, sexual assault and abuse, child raising. In our societies and, you know, the way our systems were set up, our women had a voice, and we had a powerful voice, and we were a part of decision-making in every aspect, including the land and water. And our women want to take a place back at these tables where they are able to speak. And I think it's really important that we start really looking at the structures that we have, because I've heard one of our elders, and I've heard a few people say it's been 50 years and what has changed. And I think it's time we start looking at the structure that we started back then and seeing if it works for us. Is it working for us? Because I don't think, and I heard this from another woman before she left, it's not appropriate for a man to stand up and give permission to a woman elder to have a voice at this table. It shouldn't be that way. One of the things that we wanted to look at was the structure, the system, and the policies, and review our policies and ask ourselves, are they creating a space for women to speak up without fear? And are there policies in place to back up women in leadership? I think the system's really crappy. I went to the Assembly of First Nations and I watched how the entire thing ran. And 522 chiefs and proxies came to vote, and they said the chiefs have spoken. But I don't even want to say how many of those people that were there were actually chiefs. And on the last day, the day where we had to do really important business, where we had to pass resolutions that set the mandate for the Assembly of First Nations for the rest of the year, there were 66 people left in that room. What kind of system is that? What kind of representation is that? Our children, our youth, our elders, our women need our men to be courageous and question the systems that are in place, because these are patriarchal systems that have been pushed upon us, and they're comfortable systems that don't accommodate the rest of us. We have an opportunity to do things differently. There are young leaders that come to this table that don't feel like they belong either, and they don't come back, or you don't see them coming here because they feel pushed out. Because it's the same perspective, our group of people that keep coming because they're comfortable in making the same decisions together. They're comfortable with how this system is set up. And it doesn't make space for those other groups. And I think we really need to take a look at what that looks like. The women that were at that meeting last night said we're tired of trying to knock on the door and find a way to make space for us. And they said it's time that we start kicking those doors down and we'll create our own space. So, you know, they're on a journey. Last night we heard somebody say we need to remember who we are as women. We are matriarchs who have a voice. We are powerful decision makers. So I'm not going to take up any more time. I'm not going to go on anymore. But thank you all for making the space for me to share these words, white limb limp.
We do have a few minutes for questions and comments, but just being mindful we're heading out the doors at 3:30 for the picture. Mike 7.
Thank you, Mr. Chairman, and thank you, Elaine, for organizing the women and for being courageous to say what needed to be said. And thank you to everyone in the room that's listening. It would be nice to take this sentiment into reality, because we stand up, we put our hands up to the women, we drum the women, and then nothing changes when we walk out the door. We're treated the same way. And I've been in leadership for a long time. And the way I was treated during my run for the regional chief was unforgivable. Some of the men and the people I thought were my supporters, my friends, they weren't. And the way Sheila North was treated, they just didn't want her to get elected. They wanted to hurt her. She went to healers, and they told her what people were trying to do to her, because they don't want a woman in a position of power. God forbid. We're human beings just like the rest of you. We have your children. We take care of you. So what's the fear all about in women having their rightful place and their rightful say? It's time to get over it, you guys. It's time to start walking the talk, not just every 3 or 4 months. Pick up a drum or hold your hands up to us. It's time to start being real. Thank you, Mr. Chair.
Mike 8.
Denise Zakose means male chiefs, female chiefs, and children of the chiefs. I'm a Wet'suwet'en First Nations person from Burns Lake, which is about 8.5 hours from here, northwest. And Elaine has said some pretty powerful words. I did work alongside her for a while, and she's a very strong woman. At the beginning, it was sort of a part of the murdered and missing Indigenous women. One of my youngest daughters was murdered. She was 21. She left behind a 3-year-old that we're looking after right now. But what hurts the most is that it wasn't just losing that daughter. She was the 3rd child that I'd lost. Out of 4 live births and 1 miscarriage, I only have 2 children left. So I'm doing my best to make my family strong, to make my granddaughter strong. My granddaughter was only 6 years old, and she found out about suicide in our communities up north. And she saw an ambulance taking a teenager to the hospital that attempted suicide. And she figured suicide, death, that means I could be with Mom. And so she came home and she said that she asked her 5-year-old cousin, and she was 6 at the time, "Do you want me to commit suicide too?" And her little cousin, not knowing what suicide meant, she shook her head, yes. And I'd stopped everything. I stopped cooking. I put her on my lap, and I talked to her. I said, if you want to be with Mom, you have to be strong. You have to be strong like Grandma. After 30 years of sobriety, when I lost my daughter 5 years ago, this year's 31 years, I wanted to go back to drinking. I wanted to get high and do whatever I could to get rid of that pain. The only thing that kept my husband and I from committing suicide together was just hearing our daughter laughing in the living room. There are strong women out there. Sometimes we don't know where their strength comes from. It could come from their spirituality. Sometimes they do need their addictions to help them to cope, but it doesn't make them any less of a person. It doesn't make a man any less of a person. I've worked as a drug and alcohol counselor for over 13 years. I was on disability level 2, and I was on pretty well on my deathbed, and my granddaughter, I stayed home because she wanted me to stay home after her mom was gone. And after she turned 5 years old, she found out about Disneyland, and she says, "You can go back to work now, Grandma." And so with her blessing, I started my road to recovery. I got out of bed. I started doing acupuncture, Chinese medicine. I have half a lung on each side. But I started working to get better, to be strong again. And the strength that we need is from one another. If we can't get that, then we need to start teaching others how to have respect for us. I come from a matrilineal society where we have respect for our parents, our grandparents, our mother's side, and the father clan. And in all this, I've learned I'm a very old school person. I like things the old-fashioned way because my grandfather raised me when he passed away at 108. He was an Indian medicine man. He never put one church down. He didn't say that, oh, the Catholic Church is this, the Catholic Church is that, because they brought the residential school in. He never put anybody down. He just taught us how to pray with what we had, and we can't deny our spirit. It's just like having a bath without the soap if we don't pray. I just commend you, Elaine, on all the work that you've done. I can hear the anger in there, the hurt. It's to be expected. You're a beautiful mother. You're a strong woman. You and your husband make a beautiful couple. And I think with these resolutions, that's one thing that I wanted to make sure is with the child and family legislation meeting that we had up north in Prince George last month, is that one of the chiefs mentioned that he did not want to back up anything unless they had the grandmother's clause in there, where there is more support for the grandmothers that are raising their grandkids after the murdered and missing women, or the mothers, or those kids came back into foster care and the grandmothers got them back. There are some grandmothers that are raising the 3rd and 4th generations. That's how strong our women are. You know, we don't really see I don't want to put men down, but for a man to do that on their own, it's rare. But you see, a majority of them are mostly women. And I commend all the women that are looking after their grandkids right now. And thank you, Mr. Chairman.
Thank you, Chief. Mike 16. Just before going to 16, we got 2 more speakers, closing remarks from Mike 3, and then we have to go out for the photo shoot. If we need to continue the conversation, we can do so tomorrow morning, but we're not going to have time this afternoon. Mike 16.
Chief D. Nelson, Lillooet. I don't know if any of the leadership remember the commitment stick. It was brought about a couple of years ago by Chief Charlene Ballou from Alkali, I think, and that was the basis of the respect for women, all women, and we all have the children, the sisters, the wives, the mothers, and that's what she was trying to. The basis of our success is our healing, and that's one thing we don't really take on. And I've seen it, you know, we've looked at the moose hide campaign, same thing. And same with this commitment stick, that we go through the ceremony and everything, but we don't do the work. And if anybody was at the child and family gathering last week, it was brought up again that we're talking, but there's no action. And this was a young woman that brought it up. She said she was in the system for 5 years prior, and then she came back to say that there was nothing happened. There was no changes to, you know, the children in care, young women, you know, not being taken care of. So, you know, this commitment stick, it's a commitment to make a difference, and that's what it was brought for, and that it was for the last stand, your stake to the ground, and you will not budge to protect what is sacred. And I think we need to revisit that again and really make the commitment to carry it out. I say with all my relations, thank you.
Thank you, Chief. Mike 23.
I want to thank you for your report. The topic needs to be understood. The changes that need to be made for the proper place for the women in leadership, in our families, in our communities, in our nations. It must return to the way of our people. In our culture, we have our traditional leaders, our Giachame, and the function of our culture, the reason that the chief perhaps is such a great chief, it's because of the wife. And they're often referred to as chief makers. And they played a fundamental role in the execution, the activity of our culture and the guiding of decisions which are made. Our people, as the Musqueam Zaudeno people, have been working to reestablish our traditional leadership, and it's been a struggle. It's something that we continue to pursue for about 8 years. And along this path, I've written a few discussion documents that I've circulated. And in each one, I've asked the question of what role in the new governance structure would the matriarchs play? Because we can't build something for today based on yesterday, absent of the important and critical role that women played in our culture, our governance, and our leadership. And this continues. The Zaudeno First Nation held a matriarchs gathering this past year and began the discussions internally of how to revitalize and reincorporate this critical component of our leadership. And I wanted to share that with you, Elaine, because I hear the passion in your voice. And I wanted you to know, and I want others to know, that the work that you're envisioning is occurring in places. And it is something that won't stop. And it is something that will see the light of day. I know I can't envision a new governance structure for our people without the solid place for our matriarchs and our women to be in very key and influential decision-making roles. And so I just wanted to share that with you and to share that with the Chiefs Council, that the work that is occurring in our peoples. Gailakasa.
Okay. Before we go out for the picture, I just want to thank Elaine for speaking out. And I wanted to offer just a couple words. You know, last time, I apologize when I'm with women. I said, I'm just a man. I'm sorry about that. But as most of you know, I've been in this room for a very long time. And during my time in this room, I've met a lot of incredible people. I've met a lot of beautiful, wonderful elders. I've met a lot of, a lot of brothers and sisters. And over that space of time, I've had the good fortune to meet a lot of men. And I know there's good men in this room. And we have to be careful about the isms. We all know what racism is. Racism is when white people look at us and we're all judged just by the color of our skin. Oh, it's an Indian. I travel a lot, and it's amazing when I wear a suit and tie, the doors just fly open. But when I go in a jean jacket and jeans and a t-shirt, I've been told after coming out of an empty parking lot that there's no rooms. That's racism. But sexism goes both ways. And like I say, I know a lot of good men, that respect women, hold women in the highest regard, are good sons and brothers and husbands, and, totally love their daughters and things of that nature. So we just can't make broad, sweeping statements that all men somehow are heartless and, bad people. There are some men that are insecure and, are sexist, and they'll find their way. And I just wanted to offer that before we go out for our historic picture, because we're in this struggle together. And, we have to learn how to respect each other, to accept each other, and to hold each other up, not put each other down. And that's what's made this organization as successful and strong over the years, is the ability to hold each other up. And, I do my utmost. I've always believed in leading by example. I never felt it was my place to stand in this room and lecture anybody. I just, I hope that especially younger leaders, watch how I carry myself, and through respect, emulate me. So I just wanted to offer that. I love you all, and I absolutely mean that. I'm just so grateful that you're all here, because all of you hold the future of my grandchildren in your hands, and we need each other. We're a family. So let's go out and freeze.
Before we do that, concluding remarks, Mike 3.
So we talked about forgiveness, and we talked about healing, and we talked about the importance of all voices. And we ended last night with a song, and it was just a beautiful place to be. And the women were beautiful, and they grounded each other, and there were prayers sent out for the meeting that was coming and for protection for all of the leadership and the families. And just thank you again for all of your support. I hope that you all know that I appreciate that, because when it gets tough, when I'm at meetings, when I'm bawling my eyes out, all of the leaders come, the men and the women, and they hold me up, and they support me, and they love me, and they give me that safe space. So for those who don't know me, who've heard me speaking, this table is also my family, who has also been there to protect me. So, White Limnim.
Limnim Tichwanit. A couple of things before we go outside. It's pretty blustery and cold out there, and we're a little bit concerned about the elders. For the elders that would like to be in a picture, can you put your hand up? If there's 10 of you, we'll reserve 10 seats for you. If there's 15, so then you don't go out until the picture is ready to be taken. I see a couple of hands over here. Another elder over here. So maybe 15, 17 seats altogether. That way the elders, you don't go rushing outside. You wait till we tell you to go outside. Then it's ready to take the picture. Mike 5.
Hello, hello. Before you guys go out, we're going to sing a couple of honor songs. One for the women, honoring the Indian homemakers and all the past lady chiefs that have passed on. And then we're going to do one for the men and all the former chiefs that have passed on before we go outside. But I wanted to introduce this gentleman sitting next to me. This is Tommy Raines. He was in the photo in 1969. He was on council, he was representing our community. So I just wanted to introduce him to everybody. This is Tommy Raines from our community. So he's here to get in the picture again. So.
So as we go to the honor songs, just a reminder that this isn't meant to bring sadness or any pain into your heart. It's to pass along our love and respect for those leaders that aren't here with us today, that we honor them for being here. So it's a good feeling. It's an honorable feeling, and I encourage you to keep that in your heart. HGSM.
Hey!
So if you know where you're standing in the picture, see Doreen outside. She'll direct you to the appropriate place. Reminder, elders, don't go rushing out there. We'll invite you out there when we're a little bit closer to taking the picture. And then once the picture is taken, that concludes our day. So after the pictures are taken, we'll come back here for breakfast, and meeting starts at 9 o'clock tomorrow morning.